very briefly introduce our speakers. Debbie Feinstein heads the Arnold and Porter Global Antitrust Group. She rejoined the firm from FTC, where she was director of the Bureau of Competition from 2013 to 2017. Jonathan Gleklen serves as chair of Arnold and Porter's U.S. Antitrust Competition Practice, and in 2001 to 2002 served as chair of the American Bar Association Antitrust Law Section. Deborah Garza is a partner with Rule Garza Howley. She previously served as Deputy Assistant Attorney General and Acting Assistant Attorney General at the Justice Department's Antitrust Division, and she is also a former ABA Antitrust Law Section Chair. Finally, Dan Howley is a partner with Rule Garza Howley. He advises clients on antitrust matters, including mergers and acquisitions, and civil and criminal investigations by DOJ and FTC. So we thought we would have each speaker give sort of an opening couple-minute statement, and then we'll get into our discussion. So Debbie, if you could get us started on that.
Great, and thanks. I really appreciate the invitation to have this discussion. I think much of the guidelines are not surprising. We knew what was coming. The agency heads had made clear that they thought far too many deals that should have been challenged have gone through, and that we had a problem with M&A. So I think everyone expected there to be more presumptions of illegality, lower concentration levels at which cases would be brought, more discussion of more theories that might lead to merger challenges. So I would say I was not particularly surprised by most of this. A key feature is that much of this is very structural, that it's a lot based on numbers and presumptions, and a little bit less on delving into the nuances of when is coordination likely, when are unilateral effects likely. You see much more emphasis on kind of the structure of the market rather than the specifics of a particular transaction and how it might play out. You also see that the economics are given a secondary role. Much of that is just in the appendix. And so that also is what we expected based on what we heard. I think there's some very good things in these guidelines. I had, when I was asked months ago what I hope to see in the guidelines, I mentioned a number of things, among them clearer descriptions of cluster and bundled markets. Those come up in a lot of cases, but there was nothing in the guidelines on them. I think it was a good first pass. I don't think they went as deeply as they could have into discussing those issues, but at least the concepts are there. But I also find some things confusing about the guidelines. I think the potential competition section in particular is so wide sweeping that there doesn't seem to be a lot of limiting principle. The discussion of perceived competition says that if somebody in the marketplace, doesn't have to be the acquirer, perceives the target company as potentially getting into a market, that can be illegal, without even mentioning whether or not it has to be a market that the acquired company is already in, without mentioning whether the acquired company would have incentives to shut down that program, without saying whether the incentives would necessarily change just because the target was acquired by somebody else. I think the concepts need to be fleshed out a bit more. So those are my preliminary observations.
Thank you, Debbie. John?
Thanks. Like Debbie, it's an honor, and I'm very pleased to be here. So as Debbie suggested, there is some useful new thinking in these guidelines. We all knew that they were going to say something about labor markets, and it's helpful to have some stuff about two-sided markets and cluster markets and things like that. But these guidelines are really not new thinking. They're old thinking. If you loved antitrust in the 1960s, you will love these guidelines. I am troubled that the focus seems to be on concentration for concentration's sake, and not whether a merger is good or bad for the people who the agencies are trying to protect, whether that's consumers or workers or some other group. That's perhaps not surprising, because I think the people leading the agencies believe that concentration is a problem for politics and for our democracy. And look, maybe they are right about that. I'm not sure that they are, but maybe they're right about that. But I think that's not really what Section 7 is about. It's based on a premise, as Debbie suggested, that there's been dramatic under-enforcement of Section 7. I don't think that's the case. Back when inflation was 9%, people were blaming under-enforcement of the antitrust laws for high inflation. And now that inflation is 3%, I don't think anybody is attributing that to a dramatic increase in antitrust enforcement. So I think the premises underlying a lot of the guidelines are problematic. There is a lot of fuzziness in the guidelines, a de-emphasis of market definition and market power, focus on things like a trend to concentration that doesn't really provide useful guidance to people. I'm troubled by the hostility to vertical mergers. There is literally no mention of the elimination of double marginalization, which is a key driver of why people do vertical mergers and a key efficiency of vertical mergers. There's a concern with bundling and tying that may result from non-horizontal mergers, and I guess from horizontal mergers too, without regard to whether that bundling and tying actually harms consumers. In general, I find these guidelines really to be a kind of one-way ratchet in favor of enhanced enforcement. It's very hard, maybe impossible, to show that factors like entry will rebut a presumption of competitive harm. While at the same time, there's a very low standard for showing, as Debbie suggested, that a loss of potential competition is a problem. So look, just to sum up, to steal somebody else's good line, Luke Frobe and Danny Sokol have a new article out that say that guidelines are really about merger cost-benefit analysis without the benefits and without the analysis. And I think that's really the problem with these guidelines.
Thank you, John. Deb?
Okay, unmuted. Sorry about that. Well, I agree with a lot of what Jonathan and Debbie have said, and I'll add that to a couple of high-level observations. To me, this document is more than anything a political statement. And the message, the political message is, we intend to investigate and challenge more mergers, applying stricter and more rigid standards internally than have been used for the past 50 years. Therefore, proceed at your own peril. I think Jonathan mentioned cost benefit. I think the proposed new guidelines are going to raise substantially the cost of transactions and increase regulatory uncertainty, including, importantly, for the vast majority of transactions that may pose little or no anti-competitive risk at all. In fact, one of the hallmarks of this proposed set of guidelines is, unlike guidelines since 1982, there's no acknowledgement that most mergers are competitively benign or anti-competitive or pro-competitive. There's a real hostility built into the guidelines toward M&A. So I think a greater number of deals are likely to be scrutinized. Many investigations will likely take longer, require greater resources, as the agencies explore conglomerate effects on labor, trends to concentration, et cetera. And as others have said, this is fully intentional. The Biden administration believes the economy is too concentrated, that prior enforcement policy, including during the Clinton and Obama administrations, resulted in under-enforcement, and that a host of perceived problems can be laid at the door of under-enforcement. They take an almost moralistic approach to M&A, and the dubious position, in my opinion, that as a matter of principle, the antitrust laws favor internal growth over growth by acquisition. In my opinion, that's just bonkers. Worse than bonkers. It's bad for the economy. It's a threat to consumer welfare. I think we should want assets to be able to move to those who can extract the greatest value. We should want firms to be able to operate efficiently so that they can innovate, they can provide goods at lower costs, they can provide greater choice. It's possible to prevent truly anti-competitive mergers without adopting a blanket anti-M&A approach, which I think is what generates these guidelines. Ironically, moreover, while these new guidelines are likely to deter smaller and less risky transactions, they probably won't be a substantial deterrent to larger strategic transactions. Strategic transactions, because of the size and their strategic value, I would expect will continue to proceed, notwithstanding the higher regulatory tax. And I think that parties to those transactions will be much more willing to litigate a government challenge if necessary. And in this regard, I think you need to consider the guidelines along with other Biden administration policies like the DOJ policy to try to seek to block a transaction outright instead of seeking structural relief, like the divestiture of businesses. And all this brings me to my second observation, try to be a little quicker about it, which is that the agencies apparently think these guidelines will help them in court, and I think they're probably wrong. That appears to be the rationale for citing all the older Supreme Court cases and leaning heavily on the presumptions. However, it's hard for me to believe that that's going to work. I think we're going to talk about that a little later, so I'll just stop here with that.
Thank you, Deb. Dan?
Thanks, Glenn, and thanks for having me. I agree with what others have said, and I think to Deb's last point Deb was making, I think the agencies have a lot of work to do in court. I think recent decisions have made that clear. I think as Debbie mentioned, there's heavier reliance here on presumptions. One thing that really stood out to me is the vertical presumption that they're putting in these draft guidelines. I doubt courts will go along with that. I think, obviously if you're trying to block a deal, it's great if the court will presume you win right when you start or early on. But the reality is the agencies tend not to succeed much in litigation without the presumption. So I get why they want the presumption. I'm not sure it's in their power to establish a presumption. I think the agencies in court will risk a reaction a lot like what the court in Microsoft Activision reacted to when the FTC cited itself in its Illumina case for various propositions, which is they largely discredited that and looked to actual case law in federal court. Vertical presumption, where there's if foreclosure shares above 50%, it seems odd to me, and I think courts will have a hard time rationalizing that, separated from any incentive that the firm would have post-closing. They cite some very old case law, but they don't cite recent vertical cases such as the AT&T case, which says there's no vertical presumption. I think that kind of omission will be troubling to a court as they try to put that forward. Also, given that they have a pretty poor record, the agencies in vertical cases, I think it's a little odd for courts to then say, well, you know what, you've lost a lot of these cases, so now I'm going to presume that you win some of them. I think that's going to be an uphill battle. I guess more broadly, to the point of this webinar, I'm not sure the guidelines provide all that much guidance for certainly for business people or corporate lawyers. I agree they are in keeping with what the antitrust bar was generally expecting. I think for the broader audience of the corporate lawyers and business folks, I think what the merger guidelines probably tell them is that there's hostility to mergers and that they need to hire antitrust lawyers and prepare for a fight. I think guideline 13 is very general and is a catch-all. I think that kind of doesn't provide any guidance really at all. So I think that kind of reinforces that view.
Well, thank you, everyone. I thought it might be helpful for the discussion to have a good understanding of how the past iterations of guidelines were used. So we have two people who were in government, one FTC, one DOJ, Debbie and Deb, and then two have been out in private practice for quite some time. So I'll ask Debbie first and then Deb to talk a little bit about your experiences with the merger guidelines, both the vertical and the horizontal in the past, in your capacity at both the commission and at the Antitrust Division. So Debbie, I guess you can go ahead first. You're on mute, Debbie.
I'll really talk to the horizontal guidelines because those were in effect when I was there. We used them. It's how you trained new people to think about it. Obviously, for those of us who had been doing antitrust for a while, the guidelines are just kind of baked into how your brain works. You just know them. I was at the FTC when we started the process of the 1992 guidelines. So I was in the discussions of those. I, read so many memos when those were starting to be revised and developed, and was present for a whole lot of debates about that. And thinking about all that is very helpful as you sort of get your view as to what the structure of merger analysis ought to look like. I can't say we pulled it out every time I read a new memo to say, ooh, is this consistent with the guidelines? Because you sort of know it. Where I found it particularly useful was when we were framing things up for court. In drafting complaints and reviewing complaints, I would routinely go back to the guidelines to make sure that we explain things consistently with the guidelines. And unsurprisingly, what I found was even the 2010 guidelines, which were based on what the agencies had been doing before then and involved a lot of thought. There were things that were missing. As I mentioned, cluster and bundle markets, the discussion of targeted customers and how you related targeted customers to relevant product when you have to go before a court was sometimes not as clear as it could be, and trying to figure out the best way to explain that. But definitely we used them in that respect. I also think the 2010 guidelines were useful because they provided off-ramps. And we would think about whether or not the evidence that the defendants were coming forward really met the guidelines view of what an off-ramp was to show that a merger wasn't anti-competitive. So definitely they were useful, and they were always sitting on my desk.
Deb, Garza, any thoughts on your use for the DOJ?
So it's interesting. So I've had a few stints at the DOJ that are relevant. So the first time I was at the Justice Department was after the adoption of the 1982 merger guidelines, but before the 84 revisions. And the 82 guidelines do remind me a lot of what we're seeing now with these new guidelines, because the 82 guidelines were a significant departure from the 1968 guidelines. And frankly, just as these guidelines are kind of intended to send a message and change things, honestly, I think we were trying to do that as well with the 82 and 84 guidelines. Not to say that it was all brand new, because they were both building on a progression that had begun in the late 70s, but it was certainly a new articulation of the way that the agencies were going to look at mergers, both horizontal and vertical. So when I came in I actually worked on the 84 guidelines, and we basically used the experience dealing within the agency and with folks outside of the 82 guidelines, how they were perceived, to make adjustments in the 84 guidelines. And because we were making a substantial shift in the way that the agency would look at transactions, I think my perception is that they were used significantly by the staff. And so at the very beginning, I think there was a concentration on making sure that the analysis that we got from the staff kind of matched the guidelines, right? So we wanted to make sure that it was working with that paradigm. And that's one of the concerns, I guess, I have with these new guidelines, if they remain as they are. I assume that what will happen here too is that now the staff will have to basically address everything in those guidelines, the 13 so-called guidelines in their memos. And because of the lack of limiting principles for a lot of those guidelines, I think that's going to result in staff that are swimming all over the place, that are kind of lost at sea. And so I think it's going to create a much more difficult time for staff, and going to extend the length and uncertainty associated with merger reviews, as the staff basically strives to have to address every single one of those kinds of things that are mentioned, the labor stuff and the tendency to concentration. I expect that once recommendations go up to the front office at DOJ, for example, that the deputies in the front office are going to be looking to see how they've answered each of those questions about whether there are issues under the 13 guidelines. Now, by the second time I went in was, or the last time I was in government was, I guess, right before the Obama administration. And by that time, we had decades of experience with guidelines that had evolved, including through 92 and 2010, but were well accepted. And at that point, I don't think staff was really, we weren't, structuring their analysis around the guidelines. At that point, we were focused on the competitive effects story. The issue was, how do we tell a story then at competitive effects? And the guidelines were useful for that, but they weren't really structuring the analysis within the agency. What I found is that the memos and pieces that I would get as a deputy from the parties to a transaction, when it would come up, is that they would slavishly adhere to the guidelines in a way that really the guidelines weren't meant to be treated, to try to tell us that, well, this violates your guidelines, without actually addressing our concern, which was the theory of competitive harm. So in my experience, parties tended to misuse the guidelines or didn't use them in the way that we had anticipated. It was never a case of violating the guidelines. The guidelines were always meant to help to think about how you would analyze a transaction.
So that's a good transition into our Dan and John talking about how they as practitioners have used them. So Dan, why don't you go ahead, and then John, if you could provide your thoughts.
Sure, and you're obviously familiar with the guidelines and you keep them in the back of your mind when you're advising clients. It's not all that often that you share the guidelines themselves with clients, or at least not that I have. But they, for example, the HHI thresholds can be helpful in, kind of sizing the breadbox on potential divestitures or fixes, or fix it first, or where the problem areas might be, and helping you do that, especially in transactions where there may be multiple local markets, for example, or various products that you need to, kind of have some triaging for clients. And so I think they are useful for that purpose. They help kind of frame how the staff may be thinking about things. And so, some of the guidelines, right, will have changed a bit, but sometimes they would have, I think the last version had UPPs and things. And so you would want to make sure that you're speaking the right language at the appropriate time. I think, the guidelines do kind of crystallize trends that are in existence at the time they get passed. And so they're somewhat helpful. In litigation, they can be cited against the government, and they're usually pretty careful in how they're crafted, I think, because of that. But it's all fair once there's litigation out there, and if there's any inconsistencies with the approach, you can point that out for the benefit of your clients.
John?
Thanks. So hopefully I was one of the people who didn't do what Deb thought wasn't all that useful. Look, the guidelines are helpful. They provide a kind of checklist of issues you might want to think about. But it's not, a formula for knowing whether a transaction is pro-competitive or anti-competitive. At least until the courts change dramatically, we still ask the fundamental question, is this merger going to cause harm in the form of higher prices or something else? And, what are knowledgeable customers going to say about what's going to happen? What do you say about what's going to happen? And at the end of the day, the guidelines are a way of thinking about those questions, but aren't really the answer to those questions. So certainly, the guidelines provide some useful information. If the new guidelines change the HHI thresholds, we'll flag those thresholds when we counsel clients. But the agencies have never challenged transactions just because of the HHI levels or the HHI deltas. And I don't really think that's going to change. And in the same way, we'll flag the new 50% threshold in vertical mergers and the trend to concentration point in the new guidelines. But again, I don't really think an experienced antitrust lawyer is going to tell a client not to do a vertical merger just because it has a 50% market share. The question is, what's the theory of harm? You still need to think about ability and incentive to foreclose, right? The problem with Microsoft buying Activision wasn't that lots of competing game studios write their memos in Microsoft Word, and Microsoft has a high share in word processing software. That's not the way you do vertical merger analysis. So again, I think it's helpful for issue spotting, and have it in the back of your mind, but it doesn't tell you, and it doesn't really tell the agencies whether a merger is pro-competitive or anti-competitive, which at the end of the day is the question that I at least hope we're still trying to answer.
So in your responses, you talked about the use of the past guidelines by those within the agencies, by practitioners, and being cited by judges. Thinking of all of that, Debbie, who do you think is the audience for this particular iteration of the mergers? To whom are they speaking?
I mean, the agency heads have talked about the need to make antitrust more accessible and make the guidelines something that business people can understand. But I'm with Dan. I don't think I've ever had a client interested in reading the whole document, nor could they really make sense of a lot of it, because so many of the presumptions derive from what the relevant product market is. And business people's view of what the relevant product market is and a legal view of what the relevant product market is are two different things. So although I think it was written to try to appeal to business people, I'm not sure that it's going to do that. I think somewhat it was written to appeal to a judge who doesn't necessarily have all of the economic background. That's clearly at the end of the day who they're trying to get to. And I think there's also some sense that they're trying to make sure practitioners really understand how serious they are about bringing enforcement, and hope that we will translate that to business people who may pause on doing a deal. I mean, not a new concept. I mean, Bill Baer talked years ago about, some deals should never get out of the boardroom, and wanting to deter companies from ever starting down that path. And I think you see the guidance here trying to keep people from doing deals that ultimately the government will have to challenge by having a mechanism, the guidelines, to explain why those deals are going to be problematic.
Deb Garza, you had mentioned in your opening that whether or not judges will find these guidelines worth citing or persuasive, and the authors of past guidelines have always spoken with great pride about how frequently judges have cited to the guidelines in their rationale or when they're trying to make a point. Do you expect the same amount of respect to these? And I guess the other question is, as well, if you don't mind answering, is will government prosecutors feel comfortable going in to courts arguing these guidelines if they're not consistent with what that particular judge has heard from appellate courts, the Supreme Court? You're on mute.
I'll address the last question first, which is I'm expecting that the DOJ and FTC prosecutors are going to be expected to go into court arguing like these guidelines. I mean, the guidelines, other people have commented that the guidelines read more like a brief than anything else. So I do think that the agencies are going to try to go in and tell the court, no, you have to block this because of Philadelphia National Bank and Brown Shoe, et cetera, which are already cases that are cited. But to answer the first question, is whether the guidelines are likely to garner much respect from the judiciary and adherence by the judiciary. I don't think they will, sadly. I agree with folks that, I mean, I appreciate, I think that the agencies, to me, in part, they wanted to message, don't do transactions because we're gonna make it hard for you. But secondly, it was designed to try to improve their win record in court. But sadly, I don't think this is going to help. Prior guidelines, I think, gained the respect of the courts because they provided a cohesive framework that assisted the courts in determining whether the effect of the transaction may be to substantially lessen competition, right? By creating, increasing, facilitating either unilateral or collective exercise of market power. That's the question that a court has to answer. What's the likely effect here? And past guidelines sort of built on existing law, the same law that's cited in these current guidelines, but provided a roadmap based on widely accepted sound economic principles for determining when a merger or acquisition could be anti-competitive. These guidelines, as I mentioned before, kind of read like a political manifesto more than actual guidelines. And so the agencies seem to want to we want to ditch that roadmap. We want to ditch all the merger case law that has developed in the lower courts over the last many decades. And we want to try to substitute presumptions that don't exist in the law that we've just made up. And I just don't think that's going to work. As I think Dan mentioned, presumptions are adopted, antitrust law presumptions are adopted by the courts based on well-accepted economic learning and years of experience with the fact scenarios. And if you look at the economic learning and you look at the record of merger challenges, they don't support the adoption of these presumptions. You need only look at some of the more recent merger challenges where the FTC in particular has lost, including Meta Within, and at least at the lower court level, Microsoft, Activision. You can go back and look at the AT&T case during the Trump administration. And as Dan mentioned, Judge Corley criticized the fact that the FTC in the Activision case based its incentive and ability argument on its own decision in Illumina, which had no support in the case law. So, we're not seeing it now. The agency is already trotting out these ideas now, and they're not succeeding. And I don't think that putting forth this document is going to help them at all. And to that end, you didn't ask the question, but I also not clear to me how durable these guidelines were. The 82 guidelines, the 84 guidelines, they were durable. They changed, right? And they were continuing to be improved upon all the way through the 2010 guidelines. But there was a consistency there. And I'm afraid that what they've done here with these guidelines is set themselves up so that the next administration may simply take those guidelines, put them aside, go back to the 2010 guidelines, maybe incorporate some of what is in these guidelines with respect to platform, mergers involving platform companies, some of the cluster market stuff and that Debbie mentioned. Some of it might go in, but my prediction will be that courts won't rely on it, and that at first opportunity, they're going to be put aside, and the 2010 guidelines are going to be resurrected.
Dan, was it a wise decision on the agency's parts to separate to have one document rather than two documents in terms of the horizontal and the vertical merger guidelines? Was it a wise choice for them to put the two together?
Yes, my view is I don't think it matters whether there's one document, two documents, three documents, 13 documents. I mean, they're kind of statements from the agencies on what they may do. I don't think courts are going to care whether they're together or separate. And I don't think the bar is going to care all that much. I understand maybe some of the reason that they wanted to put them together is to do away with or maybe obfuscate the distinctions between horizontal and vertical transactions. I don't think it's going to succeed in doing that under the case law either.
I think one area where it's particularly problematic is the discussion of efficiencies. And look, in horizontal mergers, efficiencies rarely are determinative of the outcome, and the kind of minimization of efficiencies, while overboard is not all that different from the way I would usually counsel clients in a horizontal merger. But there's just no separate discussion of efficiencies in a vertical merger, which is nuts, right? I mean, one interesting debate is whether elimination of double marginalization is actually an efficiency or should just be considered as part of the government's affirmative case. And the guidelines just, don't address that at all, but also just don't grapple with the idea that vertical mergers are kind of by their nature efficient.
Deb, you wanted to note something?
Yeah, I'm glad Jonathan mentioned efficiencies. The one thing that really troubled me about the efficiencies discussion, I'm not muted, right? Okay. The one thing that really troubled me was this notion that that they'd be worried about a trend in vertical mergers, that they'd be worried about a trend. If in order to gain certain efficiencies, we were going to see a trend of acquisitions to gain these efficiencies. And that's really concerning to me. I mean, it seems to ignore the possibility, well, maybe maybe because of the technology, there are some scale efficiencies that are important, and you're going to have some smaller firms merge, and that's going to be pro-competitive. But then when you look at the thresholds for concentration and the market shares and the increase in concentration, these guidelines would suggest that that's not going to be recognized. And in fact, these efficiencies that we have thought about as really being good for consumers, all of a sudden are going to become bad, right? So the efficiency is bad, just the old European approach. The efficiency is bad. We're going to block the transaction because, now everybody's going to want the same efficiencies, and we're going to have a trend to concentration because of the result. I mean, that really, really troubles me.
Stick with you for a second there, Deb. Carl Shapiro has written that in this draft, market power is no longer the benchmark for agency challenges to the detriment of consumers, he thinks. Would you agree with Dr. Shapiro in that conclusion?
I completely agree with Carl. What he said, exactly. And I share his dismay. I recommend his comments to folks. And it's interesting because, and I don't like to necessarily place people, but I think some people would think about Carl as being sort of maybe a tiny bit left of center, would think about me as being maybe a little bit of right of center. But what these guidelines have done is brought everybody to the left and right of center together, because we all seem to have the same concern. And so, I mean, I wish I had said what Carl said, and just so listeners know, what he said is that the draft announces a dramatic shift in merger policy. It abandons the focus on market power that has been fundamental to all merger guidelines for several decades, by which he means whether it's a Democratic administration or Republican administration, it's been a bipartisan recognition. As a result, the framework it offers for reviewing mergers is disconnected from the central harm that merger control seeks to prevent, namely harm to consumers caused by lessening competition. And I completely agree with him. And my concern is, and some people might say, well, but that's not really what they meant. My concern is that's exactly what they meant. And the other part of what Carl said in the article, and I really am so happy he said it and wholeheartedly agree. He said, unless revised, protecting consumers will no longer be the Biden administration's stated goal of merger enforcement. That would represent a fundamental and reckless change from 40 years of merger guidelines spanning many administrations. I totally agree with him. I think that I'm glad he made the point, and I would add to that. And he also, by the way, perceives a hostility to mergers in the guidelines, which I agree with. The one thing I would add is I think, ironically, that these guidelines, therefore, could be a real setback to merger enforcement. As a former government enforcer, I do believe that some merger enforcement is appropriate and necessary. I do worry, for a lot of the reasons that we've mentioned here, that these guidelines will be a setback to that merger enforcement policy.
Debbie, there's been some discussion about the issue of presumptions, and there are quite a few presumptions in the guidelines. What are your thoughts on that? And isn't it usually the courts that create the presumptions and the whole process of who gets to make the case and then who has to rebut the case?
There have always been presumptions in the guidelines. And in fact, the numerical presumptions here for concentration levels and changes of concentrations take us back to the 92 guidelines. So they're not particularly surprising. There's a reason that the 2010 guidelines moved to the higher numbers. And I think that's because the evidence showed those were in fact the numbers at which the government was bringing cases, right? The 2010 guidelines were really all about kind of codifying what was happening and how they were doing things, as opposed to, okay, we've been doing it this way, let's come up with new guidelines to change how we're doing it. Remember, the guidelines were preceded by the merger commentary. And the merger commentary laid out how it was that the agencies were actually doing this. And for a number of years in the 90s and 2000s, there was an economist at the FTC who went in detail through every recommendation memo for enforcement actions or non-enforcement actions, and he would categorize it. He would look at, were there HHIs in the memo? What were the HHI numbers? How many competitors were there? Were there complaining customers? Were there arguments about entry? There's a litany of it. This is Malcolm Coate. at the Bureau of Economics. It was enormously helpful. It was one of the most helpful documents in using with clients, because you could say things like, look, when it's a 2-to-1 merger, 99% of them get challenged. When it's 3-to-2, it's 87% of them, and the ones that don't, it's because entry is really easy. And you could go through and say, here are the factors that are really being used. And I think it was some of that analysis that led the agency to say, look, there's not really an empirical basis for using particular concentration numbers, nor is that in fact what we've been doing. So the 2010 guidelines tried to say it. I think this agency is saying it's not what we're going to do. We're going to bring these cases at the lower levels. You should be aware. So not particularly surprising. And Philadelphia National Bank gives enough on horizontal presumptions and 30% that I think the agencies will say that's consistent. Where they go into new territory, as Jonathan and Deb mentioned, was in vertical transactions. We're saying that there's a presumption at 50% when they haven't gotten cases blocked. I think it's hard for judges. So where did this number come from? What's the basis for it? What's the case law for it? I think that's going to be an issue. Similarly, they look at, in potential competition, they say if a firm has a reasonable probability of entering the relevant market, doesn't matter how many other firms have reasonable probabilities, the agencies will presume that such entry would result in deconcentration of the market unless there is substantial direct evidence that the competitive effect would be de minimis. So first, okay, sure, any new entry could result in deconcentration of the market, but by how much? Does it matter? Is it unique entry? I think that kind of presumption is not going to be as well received by the courts, particularly when the flip isn't going to be the case, where parties are arguing that new entry is likely to happen. You won't get any kind of presumption that new entry, even if it would happen, is going to be deconcentrating. And so I think those presumptions are going to face greater pushback by parties and in the courts.
Debbie mentioned, John, the potential competition issue, and Guideline 4 addresses actual and perceived potential competition, an issue that received quite a bit of attention in the challenge to Meta's purchase of the VR app maker Within. Do you see that those theories becoming increasingly relevant and used by the Commission and the Justice Department? And does this guideline reflect the agency's approach?
Well, so look, potential competition is not a new theory. There have been potential competition cases going back decades and decades, though there's certainly an interest in potential competition, particularly involving the big tech companies and focused on nascent competition in technology markets. As a couple of folks have suggested, the agencies have not had a lot of success in bringing potential competition cases, and the Meta Within unsuccessful challenge is really just the latest example of this. These guidelines take the most enforcement-friendly approach possible. They say that the agencies, need only show the reasonable probability of entry, as Debbie mentioned, to show a loss of competition. There's some cases that talk about clear proof, and there's an old FTC case, British American Tobacco, where the FTC itself used the clear proof standard. In Meta Within, the court said that the entity has to have more than a 50% chance of entry to satisfy the feasible means of entry requirement. But as Debbie suggested, the agencies, say they're going to view entry as feasible as long as the company has the resources or has successfully entered other markets, or even if it just has an incentive to enter. So it's really kind of defining potential competition down is a way of thinking about that. I think that on perceived potential competition, the guidelines ask not whether the fear of entry by a firm has in fact constrained competitive behavior, but only whether a market participant, reasonably could consider the firm a potential entrant, and if that perception has likely influence. So, look, I think the agencies are very concerned with nascent competition, particularly in tech. They want the guidelines to make it easy to defend challenges to acquisitions of nascent competitors. But I don't think these guidelines, for the reasons others have suggested, are going to be all that influential in the court. If circuit precedent says what the standard is to prove a potential competition case, I don't think a court's going to say, well, we're going to ignore circuit precedent and look at what the guidelines say. I think the real hope at the agencies is to make people think twice before selling to a big tech platform, because they're going to see this kind of thing and say, gee, you know, Google or Microsoft or Meta will pay me X, and somebody else is going to pay me, you know, 0.95X, and life is too short to get caught up for another year or year and a half to make 5% more. And if that's the signal that the guidelines are trying to send, and the agency really is going to bring those cases, having the guidelines set that out is, I guess, useful guidance, even if when it came to litigating these cases, doesn't mean that the agencies would actually win.
Looking at another specific guideline, Dan, number 10 offers the agency's thoughts on mergers involving multi-sided platform, which was the topic of the American Express case in the Supreme Court some years ago. What are your thoughts on that, and how closely does it hew to the case law that's been out there?
So I actually thought guideline 10 could be somewhat helpful to parties in providing kind of a construct and a checklist to go through on platform deals. I don't know that it's fully consistent with Amex. There's statements in Amex that one of which was cited in the Sabre Fairlogics case about two-sided platforms only being able to complete with two-sided platforms. I'm not sure that's factually always correct, and I think although it may be in some cases, and I think the guidelines are picking up a little bit on that in talking about competition to displace platforms. And so I actually thought that was a somewhat one helpful, and at least to me, less objectionable guideline.
Debbie, we've talked a bit about some of the cases that the agencies have litigated leading up to the release of these guidelines. Are there any that are out there now in litigation or potential litigation that you're going to be keeping an eye on as to sort of create an idea of how the courts might look at these guidelines if the guidelines are reflected in the challenges that the agencies are bringing?
I think Amgen Horizon is one to watch. The parties are, the FTC is arguing that Amgen may engage in bundling that may be anti-competitive. The FTC's never brought a bundling case, and now they're bringing a challenge to a merger that may lead to bundling that may be anti-competitive. And the parties are arguing that that is entirely speculative and not a basis for a Section 7 challenge. How the court deals with all that, there is no precedent, and the agencies will be arguing, if I'm not sure the guidelines will be out before that case, but the concepts will be will be there, and I think that will be interesting to see how the court reacts to that. And just to make a point, following what Deb said a while ago, which was, how will the courts respond to these guidelines? I'm intrigued by the notion that the guidelines are going to be better for the government because the government seems to think that the guidelines are going to be better for them because they're based on case law, but they've been citing the case law in their cases, and the case law either supports or doesn't support. I don't know how guidelines are going to change that view of whether a particular case does or doesn't support the government's theory, presumably, brief writing lets advocates, argue both sides of a case. So it'll be interesting to see how all this plays out.
I'll throw this out to anybody who'd like to react to it. Did the agencies miss any opportunities to clarify their approaches or advance certain doctrines in this draft that aren't in there?
Look, I don't think they're missing a lot. They seem to have covered the waterfront. One thing they could have said, I think, particularly Lena Khan at the FTC just believes that concentration is bad for democracy and bad for politics. I think they could have actually said, we're going to focus on industries that have significant impacts on our politics and our democracy. And I'm not troubled by somebody saying, we're going to think about a newspaper merger a little bit differently than we think about a widget merger. And we might actually care about other avenues of competition beyond price competition. If if Mike Bloomberg wanted to buy Fox News, the fact that there are lots of other news channels on cable TV, I could imagine them saying, that's something we want to think about. But in general, I think they covered the waterfront of the kind of hot topics in mergers. They certainly could have provided a lot more clarity about what counts as a trend towards concentration and things like that. But I don't think they missed big things.
Deb, go ahead.
Yeah, I mean, I think given what they wanted to do, I think they missed an opportunity. Going back to what Carl Shapiro had said, I think they missed an opportunity to make the guidelines more effective by not connecting up the guidelines, the 1 through 6 guide, not connecting 1 through 6 of the guidelines to economic principles, to market power, to showing what the connection is between this broad statement that they make and how it could actually end up affecting competition. And so they could make the guidelines a lot better and more effective if they kept the structure of these 13 so-called guidelines, but made more of an effort to explain the connection between concentration and competitive effects.
And Debbie, any thoughts on missed opportunities?
I mean, I don't know that this is a new thought given what others were saying, but it is like written a bit like a brief, but a brief that doesn't reflect or address the relevant case law. And so I think that's a missed opportunity. I mean, maybe that's intentional, but I think it makes it less persuasive.
Yeah, and I'm going to follow on what Dan said. I find it surprising. There's really good case law for the government on unilateral effects, which is not necessarily intuitive, right? And that's something that we had to bring courts to over time. There's good case law on targeted customers and, the evolution from a submarket to targeted customers, which are kind of different things. But having some good case law on that and not citing some of the recent case law was surprising to me. If you're and it's not as though it's only old case law. There are some of the new cases that were cited. I think ProMedica is in there, which is a relatively recent case. But some of the other cases, Tax Act H&R Block, a classic case that says you don't have to be each other's closest competitor for there to be an adverse unilateral effect. I think a powerful case for the government that really spells things out. Now, of course, if you have a unilateral effects case, you're going to put that in the brief, sure. But once you go down the road of citing cases and citing relatively recent district court cases, I think that most government enforcers can pick the 1 or 2 during their time that they are most proud of, and none of those cases are cited. There's an almost entirely lack of that, and I'm not sure why.
These are drafts, so obviously there's going to be an opportunity for public comment. John, do you expect a great deal of public comment?
Well, I expect a great deal of public comment in the same way that the agency has got like 30,000 or however many thousand, comments from people who just filled out the form on the web. Do I expect there to be lots of insightful comment? Look, there are going to be some organizations that will spend the time and the money to put together thoughtful comments. There aren't going to be dozens and dozens of those, but there will be some. Whether that is going to make a difference at the agencies, I don't think we're going to convince the agencies that the introductory paragraph needs to be about how the purpose of Section 7 is protecting consumers from higher prices. And I don't think we're going to convince them that to take out the stuff about a trend to concentration or a trend to vertical integration. There may be some changes at the margin, but in general, I think these guidelines are supposed to describe how the current leaders of the agencies want their staffs to go investigate mergers. And having people in the private bar saying you should go investigate mergers differently isn't going to be very compelling to them.
For the rest of the panelists, are there any areas that you think are worth commenting on? Deb?
I mean, I do, you know, whether or not the agencies are willing to take under consideration these comments, I do still think that it's worth making the comments, because there are a lot of things to be said. And a lot of good points have been made by very thoughtful people, including people who have formerly been enforcers, who care very much about making sure that, you know, that merger enforcement is effective going forward. So I hope that there will be the comment, even if it's not taken on board. I'm a little bit, it's sad that this administration came in with the sort of approach they did of, we don't want to talk to folks, you know, we want to talk to the folks who went before us, we're going to change things up, we want to be radical, we don't want to hear any input about how we can do it better, this is what we want to do. I guess I appreciate it because of the fact that they do want to make this big policy change, but as I said, even if they're not willing to listen to it, I think it's going to make for a better situation overall if people do put in thoughtful comments.
And I look, I think that agency staff, they're listening to these. I mean, I see agency staff on this call. I've seen them on other calls. I'm sure they're thinking about what we're saying and either agreeing or disagreeing that things are clear or not clear. I think they're thinking about it as they do new cases, right? And you think, okay, I'm using the new guidelines. Do they clarify this situation for me? How do I think about that? And are hopefully relaying that to others they work with as well, to make sure that they, you know, suit the needs and are sufficiently clear, you know, not only for the outside parties, but internally, so that they can work with them as well.
Any thoughts on that?
No, I agree with what Deb and Debbie were saying there. I guess I'm not very optimistic that they'll take on board a lot of the comments and make significant changes, but I can see some benefit in folks making the comments.
So everyone was either so complete in their answers to my questions, or there's just a fatigue about merger guidelines in general out there that we don't have any online participants questions, even though we had plenty of online participants, and I thank them for joining us today. Antitrust is one of the most sort of involved and busy areas of law right now. So I really appreciate each of you taking the time today to speak to us, Dan, Deb, Debbie, and John. Really, I think an important thing to continue to have more conversation about that. Oh, we do have a question. So let me ask that real quick. Sorry. What do you think the prospects for an APA challenge if the guidelines are essentially adopted as proposed, and wouldn't public commentary pointing out the lack of sound and analytic basis for such guidelines be helpful to such a challenge? Anybody who's interested in answering that one?
I think their statement, first, I haven't heard that anybody's going to challenge it, unlike the non-compete rule where I have heard that people are going to make challenges. And I think the reason is because these are just statements of enforcement intention. At the end of the day, they have to bring a case, and they have to go, they're not regulations, they have to go through a judicial process. So I think it's a very different situation than a rulemaking. So I haven't heard any buzz about that kind of a challenge, you know, nor would I expect one, because again, every case is going to have to go before a judge, and only then will there actually be an implication. So I'm not sure that the guidelines make a difference to that end calculus.
Thank you, Debbie. Well, I will finish by thanking you by thanking you once again for joining us today. Thanking everybody for participating today. This will be available on demand probably first thing tomorrow morning for those of you who might have come in late or know of anyone who might like to watch and learn from the insights of our 4 speakers. Thank you again, everyone, for joining us.
Thank you.
Thank you.
Thanks.